And welcome again, Disability Law Show. John Scholes, James Fireman joining me. Hope you're doing well on this episode of the show. We got lots to get through today, including 5 disadvantages that insurance companies have you must know about. That's coming in just a little bit. To reach out, by the way, anytime, help at disabilityrights.ca. The phone number, 1-855-821-5900. James, let's get cooking. First week that was. What do you got going on, pal?
Sure. Well, one of the things that is a big issue for anybody that has a disability claim is they're concerned what's going to happen if they start a legal claim to challenge a denial or termination of benefits by their insurer. And more to the point, a lot of people are very concerned about how long that process is going to take. A lot of people hear stories and think that it's going to take 3, 4, 5 years, something like that. And I can tell you in my experience, it is never that long. At the outside, before COVID, before the crisis, it would take at most a year in almost all cases. But what we've been finding is that that timeline has really shrunk by a fair bit, and usually it's about 8 to 10 months now. But what I've also found is that in several cases, it's still not the rule, but in several cases, we're finding that insurers are contacting us very soon after we issue the legal claim. So let me just back up a little bit. And typically the way the process works is someone retains our services. We ask the insurance company for their file. That usually takes about 2 weeks from the date that we sign the retainer. Usually it's about 1 week to review and issue the claim. So now we're 3 weeks to a month after that retainer has been signed. We will immediately ask for a mediation date from the insurance company, and then typically we'll get that date 6, 7 months down the road, so the entire claim is usually resolved 8, 9, 10 months down the road. But what we've been finding is very soon after we issue that legal claim that there are some instances, certainly more frequently than before, where we're having insurance companies contact us right away. So we're talking a month after, maybe 2 months after the retainer has been signed, an insurance company is contacting us and saying, you know what? Maybe we don't need to mediate this. Let's talk about resolving it. And I had a case that settled 2 weeks ago. We never went to mediation. Is someone that came to me 2 months ago. 2 months ago with the claim. It's a truck driver, had a very serious back injury, had been denied his benefits and then denied twice on appeal. Contacted me, retained our services, and within 2 months, we had gotten the file, issued the claim, been contacted by the insurer, and resolved it. And for a very good amount, an amount that paid my client almost all the way through the entire portion of his disability benefits. And so I don't want to suggest, if you're listening, that that's what's going to happen, because it is still an exception. But what I can tell you is if you're concerned about how long it's going to take for your claim to resolve, it isn't going to take years. That's just not the way these things go. More often than not, it's a matter of 8, 9, 10 months, but it can be sooner than that. And that is always what our objective is to get our cases resolved as quickly as we can for as much money as possible.
Do you think this is a result of technology in some way? Because of the pandemic, doing Zoom meetings and everything like that. I mean, it's not as comfortable at the beginning, but it seems to be a lot quicker now, as you said. Is that why?
Well, I think that's part of it. I think part of it is that the timeline for most cases is shorter, and I think that's exactly why. Partially technology, because people are able to communicate a little bit more efficiently. Also, I think a side effect of COVID is obviously people aren't going away on vacation as often as they used to, and so it's just easier to get a hold of people now. But that doesn't really answer why we're finding that there are cases where the insurer is looking to get it resolved very quickly. That could be just a function of reputation, or it could just be a change in mindset with some insurers. It's not, again, it is an exception where it happens that quickly, but I'm finding it happens more frequently than it used to. And I wonder whether there's just been a change in the mindset of some insurers when they know when it lands in the lap of a lawyer who's getting the file for the first time, and they're looking at it fresh from the insurance company's perspective, and they take a look at it and they see what's gone on the file, and they see that this is someone who is obviously legitimately disabled. Their entire medical team is saying that, and the insurance company doesn't have any medical basis to support a denial. The lawyer's looking at it saying, well, what argument am I going to be able to make 8 months from now? If I don't have the argument then, I don't have it now. Let's just see if we can get it resolved. That's what I think is happening.
You want to reach out anytime, by the way. We always throw the information up at the bottom of the screen, but just in case, help at disabilityrights.ca is the email address we use. Want to get to our first one for today, James. This one comes from Lily. Lily writes in, says, I'm getting disability benefits, but my case manager is hounding me to get him updated medical information from my family doctor. My doctor's office was closed for several months because of the pandemic, and now he's only seeing limited patients in person. I can't even get through to speak to him. Will my benefits get cut off?
Well, that's an interesting question, and that's really going to depend on how your insurer reacts. It is something that we have seen some insurers use as a justification to cut off benefits, but it really isn't a valid justification. If you are doing everything that you can to get treatment and to get records into your insurer's hands, they should not use the pandemic as a basis for cutting you off if you're not able to get the treatment or to forward records from your treating doctors to the insurer. But that only really is a excuse for so long. And we're now, 6-7 months into the pandemic, and at a certain point, if your treatment provider isn't providing you with treatment anymore or isn't responding to requests for records, it may be time to start thinking about whether or not you need to find another treatment provider, because after a while, the insurer will be justified in saying, well, listen, we don't have any updated medical records, and we're sorry that you're not able to get the treatment or your treatment provider isn't giving you the records that they should be, but that's not their fault. At a certain point, they don't have to be understanding anymore. And so if it's been going on since March and they don't have any updated medical records and they've been asking for it and giving you reasonable chances, then it might be time to start thinking about a new treatment provider. But I say that with hesitation because by far, the most important thing in this process, we're dealing with people who are disabled. If you are watching this show, it is because either you or someone that you care about is disabled. And the most important thing is making sure that the people who are in that position are getting the best medical coverage that they possibly can. And so that means, number one, not doing anything to interfere with the relationship between the doctor and those people who are disabled. And so if you have a relationship with your doctor and you really are opposed to finding some other treatment provider because they're not being responsive, then you have to be a little bit more aggressive at a certain point. If that isn't the case, if you're comfortable seeing someone else, then it probably is time at this point to start looking to see if there's somebody else that might be able to provide you that treatment that might be more responsive in getting those records to support your claim.
It's good advice because I know a few people that are close to me, their doctors have just packed up shop since COVID hit, and they didn't know this for 5 months, that they no longer had a doctor. Now they have to go to some warehouse to get the records. So it's pretty good advice. It really is. Yeah. We're going to take a short break here. We'll get to 5 disadvantages the insurance company has that you must know about. But to reach out in the meantime, 1-855-821-5900 and help@disabilityrights.ca. You can simply go to disabilityrights.ca, the website as well. We'll continue on the Disability Law Show. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Welcome back, Disability Law Show. John Scholes, of course, James Fireman, answering all your questions, giving us the information. The number to call out anytime, 1-855-821-5900. help@disabilityrights.ca. We'll get to another email very shortly. James, want to get into our topic for the day, 5 disadvantages insurance companies have that you must know about. Number 1 is this: insurance companies focus on how rampant fraud is to dissuade legitimate claims. How about that?
Yeah, you see these stories pop up once or twice a year, and insurance companies are, claiming that they're losing money left and right because people are faking injuries or faking disabilities. You see it actually a lot more in the automobile sector, but you do see in the disability sector too. And it reminds me of the street card game, 3-Card Monte, where they're showing you one thing and it's basically just all sleight of hand. They're trying to distract you from what's really going on. And what's really going on, if you just look online, look up what insurance companies are making. They're making money hand over fist. They're making millions upon millions, even billions of dollars. So it is not an issue for the insurance company. Fraud is very small. I'm not going to tell you it never happens. All I can tell you is, as someone who practices in this field, I would never be interested in taking on a case that to me didn't seem to be completely legitimate. And before I ever issue a claim, number one, I'm certainly talking to every client that I sign up, thoroughly interviewing them and making sure that my spidey senses aren't tingling. But then I get the full insurance file and all of the medical documents. And unless there is absolute support from the doctors that this person has a legitimate injury, I'm not going to start, or disability, I'm not going to start a claim. It doesn't make any sense. The lawyers that practice in this field work almost exclusively on a contingency fee basis, which means that we're not going to get paid unless it's a legitimate claim. And while I don't think fraud is rampant at all, in fact, I think it's incredibly rare, I know insurance companies are certainly trying to look for that, and anytime they might be able to suggest it, they're certainly going to try and do it. And so I'm not going to take on a case that's going to make their life easier or risk my firm's time and money in a case that I don't think is going to be successful. But I can tell you that almost never happens. It's incredibly rare that someone contacts me and their case doesn't really check out. Now, there are times when people will contact me and they just don't have enough to bring a claim, but that doesn't mean that they're making things up. It just means that they can probably work, and their doctors are telling them that as well too. So fraud is really not an issue that we see with any consistency at all in the disability realm.
Another disadvantage insurance companies have you should know about is the fact that adjusters have many, many files and likely don't know the specifics of yours.
Yeah, this is a big issue for the insurers. They have adjusters that are carrying 200-300 files at a time. Oftentimes the adjusters simply aren't trained the way that you would want them to be. So you're talking about people who are way overworked that don't have the tools and resources available to them that are going to allow them to be able to really understand the file the way that they should and devote the kind of time that they need to in order to fairly adjudicate the file. And when you add to that they have different motivations than you would hope that they have, it means that it's almost impossible for most people to get a fair shake.
Another third one of the disadvantages insurance companies have you got to know about is this. The main concern of the insurance companies is the bottom line.
Yeah, I was tipping my hand a little bit on that last answer. This is really what drives decision-making for the insurers. This is what they are about. They are corporations. They have shareholders. They're in business to make money, and that's fine. They're trying to make profits for their shareholders. I don't begrudge them that, but if you are someone who is trying to get money from an insurance company, you need to understand that. You need to understand that the insurance company is there to make money, and they're not making money if they're paying you. That is what their objective is to find a way to stop paying your benefits or to just deny them outright. This is how they make their money. Forget what they advertise on TV. They're not your good neighbor. They're not the friendly little lizard that's up on a log making jokes to you. They're none of that. They are there to make money. That's it, plain and simple. And because of that, they're going to cut corners. They're going to do things quickly and easily. And a lot of times they're going to do things very sloppily in ways that make it actually quite easy to turn it around on them if you know what you're doing. So if you hire an experienced lawyer to bring a legal claim to challenge a denial that's not justified, it is almost always the case that there are going to be 5, 6, 7 things that the insurer has done that really expose them to extra contractual damages, to money outside of just the benefits that they owe you on the policy, money that they would have to pay as punishment for the way that they've handled the claim and their failure to treat you fairly.
Well, that's number 4. You alluded to it, the 5 disadvantages, that adjusting files is a tedious process, and there's likely going to be mistakes.
Yeah, this is a function of the volume in the file. There's usually, 400 or 500 pages. I've seen some that are as big as 2,000 pages, and you cannot possibly argue a file or be able to adjudicate a file unless you are familiar with everything in there. And so when I'm going through a file, when I'm preparing to negotiate for a file for mediation or for settlement purposes, I have gone through every single page in that file, and I've created a chronology, and I know exactly what's gone on. And I can assure you that the adjusters who are adjudicating these files when you make your claim and who are responsible for deciding whether or not you're going to get approved initially or whether or not your appeals are going to get approved, they are not going through it with that kind of care. And very frequently, it's not the same adjuster that is there from start to finish. We hear stories all the time from clients that tell us that they've had 4, 5, even 6 different claims handlers or adjusters on their file from the time that they started. And you get to a point with one of them where you think that they understand you, they understand your condition, what's going on, what your treatment is. And then the next thing you know, somebody else is on the file and you're starting from square one again. And I don't know if that's by design or if that's just the way that it works, but it is definitely an issue. The insurers are almost never in a position to fully understand what's in the file and to be able to fairly adjudicate it.
All right, disadvantage number 5, James, a big one here. They rely, they feast on the power imbalance, and they assume that you are and always will be very vulnerable.
Yeah, this is true up until one very particular point in the process. So when you make a claim, when the insurer is adjudicating that file, or if you decide to appeal, and please don't do that, we'll talk about that at some point, but as long as you are within the insurer's process, anywhere within those things I've just talked about, the claim or the appeal process, the insurer is controlling every part of that. They're making up the rules. They are the ones that also get to decide what the outcome is. Even on the appeal, if you appeal, it isn't going to someone independent who's looking at it with fresh eyes. It's going often to the very same claims handler that made the decision in the first place. So they have all of the power until you bring a legal claim. They cut off your benefits or they deny your claim, you can bring a legal claim and challenge them within the court system. Now again, it is incredibly unlikely that a long-term disability case is going to reach a trial. That virtually never happens. It's not impossible, but it's very, very unlikely. But as soon as you start the legal process, now the insurer is no longer in charge. They don't get to set the rules. They now have to be reasonable because they know if they're not, they know if they continue to be intransigent, if they continue to ignore what they're required to do under the policy, if it ever went to trial, they would be in really hot water. If a judge is looking at it and they see that insurer continued to act unreasonably, to not act in good faith, to not fairly adjudicate a file, and that reached a court, they would be in big trouble. They'd have to pay punitive damages in those cases.
Isn't one of the side benefits as well of starting a legal claim is that the insurance company and or the adjuster stop with the phone calls to the person who's on claim, pestering them. They don't deal with them. They can't deal with them directly anymore, can they?
Yeah, no, that's an enormous benefit.
Yep.
It's one of the things that I hear from virtually every new client that I speak to on the phone. One of the things they're concerned about is, James, I just don't want to continue in this process. I don't want to have to deal with the insurance company. And that's when I get to give them the good news. Because as soon as a retainer is signed, we send a letter immediately to the insurance company letting them know that we've been retained. And from that moment on, all communication has to go through my office. They cannot call you anymore. They can't email you anymore. That stops. And what I tell all of my clients is that you no longer have to worry about the insurance company. All of the day-to-day running around, getting documents, all of those things that are required for the legal claim, my office is going to do that. We'll get authorizations from our client. We will do all the grunt work. That's not for our clients to do. Our clients should focus on their treatment and rehabilitation, and they don't have to worry about fielding calls from adjusters anymore.
Let's take a short pause. When we come back, James, this one, my doctor says I'm not totally disabled. How do I start an LTD claim? We'll get to that. In the meantime, 1-855-821-5900. help@disabilityrights.ca is the email address. Coming right back. More Disability Law Show.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back, Disability Law Show. The website, disabilityrights.ca, anytime is there for you to use. You want to reach out, you can make a phone call, 1-855-821-5900, and the email is help@disabilityrights.ca. That is where we're going to go, James, now for Brandon. Brandon says, guys, my sister went on long-term disability due to depression at the urging of her psychiatrist. Even the insurance company's own doctor determined she can't work. A few months ago, she got a letter saying her benefits would be cut off in 6 months because her family doctor told the insurance company she might be able to work at another job as long as it was only part-time as a way to cope. Can the insurer cut her off in this case?
Well, that's a really good question. And so, first of all, I want to just thank Brandon for writing to us on behalf of his sister. If you have a family member or a friend, a loved one, a coworker even, that is in this situation, that is having a difficult time with their disability insurer, please feel free to call us on their behalf. You don't have to give any personal information about them. You can just call and get information. It's 100% free. No one's going to ask for a credit card. You can just get the information. If they want to follow up on that and go any further with the process, that's perfectly fine. But if not, that's great that you're able to get that information on their behalf. So, Brandon, I do really appreciate you reaching out on behalf of your sister. Now, for the benefit of our viewers that may not be as familiar with the entire long-term disability process, after 2 years of getting benefits, the test for receiving benefits changes. So up until the 2-year mark, the test is whether or not you have a disability that prevents you from doing your own occupation. After 2 years, it now becomes whether or not you have a disability that prevents you from doing any occupation that you're qualified to do by training, education, or experience. But here's the thing, what is very rarely written into the policy, but what every judge that sees one of these cases is going to say, is that even after the 2-year mark, even if the insurance company is able to find a job that you are able to do, an occupation that you're qualified to do and medically fit to do, it still doesn't count unless it's going to pay you what they call commensurate income. And so that means that the insurer essentially has to find a job that's going to pay 60 to 65% of what you had been making, which is usually more or less about what the insurance benefits are. So unless the insurance company is able to find an occupation that you can do after 2 years that's essentially going to replace the benefits, then they remain on the hook. So looking at Brandon's sister's situation here, now I can't say for sure whether or not this job would qualify as commensurate income or not, but based on what Brandon's sister's doctor is saying, that she might be able to do some part-time work, I could take a guess that it probably won't. It probably isn't going to be sufficient for her to be able to make that commensurate income. And if it doesn't, then she's going to be entitled to those benefits. So as long as that's the case, it's certainly something that she would be able to challenge. The last thing I want to point out, though, is the insurance company has done her a little bit of a favor here, whether intentionally or not. They've let her know 6 months in advance that they're going to be cutting off her claim, that they're going to be cutting off her benefits at the 2-year mark. And that is a really big advantage because we can start the claim now. We don't have to wait until those benefits stop, and you don't want to wait. If you wait 6 months until the benefits stop and you start it only then, it's going to take an extra 6 months before you get it resolved. If we start it now, more than likely, it's only going to be maybe a month or 2 months, perhaps 3, until we're able to get the claim resolved. And there's at least a decent chance that we get her claim resolved before the money stops flowing, which would be wonderful. It would be great if she wasn't in a situation where she had no benefit money coming in. So that is actually a really nice benefit of your insurance company telling you so far in advance that they're going to cut you off. You can do something about it, and you should. Don't wait.
Let's move on to another email. This one from Malik. Malik says, I've been unable to sleep due to intense back pain caused by degenerative changes revealed through an MRI. The pain became worse after an accident I had about a year ago. My doctor agrees that I can't do my job, but he says that there's no point applying for disability because I'm not, quote unquote, totally disabled. I can't do my work, so how am I not getting long-term disability?
Well, it's a really good question, Malik. And what this really comes down to is understanding what that phrase total disability means. And so I want to caution you out there, if you are watching this show, legal advice is, you get it from your lawyers, you get medical advice from your doctors, and be careful about that distinction. And so your doctor has done exactly what the insurance companies want him to do, and he's interpreted the phrase totally disabled in a way that is not actually intended in the policy. Here's what I mean by that. If you are talking to someone in normal conversation and you say, I have this friend who is totally disabled, it conjures up an image in your mind of somebody who probably can't get out of bed, who can't feed themselves, who can't bathe themselves, who can't put their clothes on, certainly can't get out there and drive and go get groceries and any of those things. And so when you hear the phrase totally disabled, that is what most people think of. But that is not at all what it means in the context of long-term disability. In a long-term disability claim, the term totally disabled is defined in the policy, and what it means is set out very specifically. It means that you have a disability that prevents you from being able to do your own occupation. That's all it means. Has nothing to do with whether or not you can get out of bed, has nothing to do with whether or not you can go get your groceries. It even doesn't have anything to do with whether or not you're able to have some fun with your friends and go out and have a good time. All of those things are very possible for someone who is totally disabled under the policy, because all it means is that they are not able to do their own occupation, or after 2 years, as I was explaining before, any occupation that you're qualified for. And so, Malik's doctor here is unfortunately incorrect, and it's something that it could easily be challenged in this circumstance, provided that his doctor is at least going to be of the view that he's disabled from returning to his occupation. So it's absolutely something that can be challenged.
Again, reach out to Malik, 1-855-821-5900. I think we have enough time to squeeze Cheryl's email in here for the remainder of the show. Cheryl says, my husband has worked as a full-time forklift operator despite years of suffering from liver cirrhosis sparked by alcohol abuse. Late last year, he experienced kidney failure and had to stop working. He's now waiting on the transplant list, but needs to be sober for 6 months before anything can happen. The insurance company has denied his LTD benefits because they say he's not getting appropriate treatment. Is that right?
Well, it doesn't sound like it's right in this case at all, John. So in the past, substance abuse claims were denied under the policy. It was something that insurers had the right to do. They would write into the policy, if you had a substance abuse issue, you weren't going to get approved for that. But that's changed. It's been found to be a human rights violation. And so if you have a substance abuse issue, if you suffer from addiction, that is recognized as a disability 100%. And so insurers are required to pay benefits as long as you are otherwise abiding by the terms of the policy. But what is pretty clear when you do enough of these claims is that they're not treated the same way. There are, I suppose, exceptions out there, but I see in virtually any case where there is a substance abuse issue, I see the insurer finding, the most ridiculous justifications for terminating benefits. They just don't like paying on cases where somebody has an addiction issue. And so they will really reach to try and find a justification. And it sounds very much like that is what they're trying to do here. So part of any long-term disability policy is going to require the claimant to get reasonable treatment. And that is absolutely a fair requirement. If you're not getting reasonable treatment, if you're not doing the things that your doctor has recommended for treatment, then the insurer can and would be justified in cutting off or denying your claim. No issue with that. But in this particular case, Cheryl's husband has gotten all the treatment that he should be getting. He's been sober for the last 6 months, and he's on a transplant list, which suggests to me that there's nothing else that he can be doing. Now, obviously, I haven't reviewed this file yet, so maybe there is some treatment that he isn't getting that Cheryl hasn't passed along here. But as long as everything that Cheryl has told us is accurate and there isn't anything else out there, I can't imagine that there is anything that would justify the insurer denying or cutting off benefits in this instance. And if they do it for somebody who is absolutely following treatment guidelines, has been sober for 6 months, and is waiting on a transplant list, and they still deny the claims, they have exposed themselves to very significant punitive damages. That is absolutely not a fair adjudication. That is not acting in good faith, and that is something that you absolutely could challenge them on.
James, good stuff. We'll leave it there. Cheryl, appreciate your email as well. You want to reach out by phone now, 1-855-821-5900. The email address we use every week is help@disabilityrights.ca, and the website is disabilityrights.ca. Lots of information for you to have there. And tune in next week and every week on the show, and we'll give it to you here, James and myself or Sivan. We'll catch you next time. Disability Law Show. Thanks for joining us.